Yes, Mr. Justice.
Thank you. If I may, I'll start with a few opening comments. One of which is to say there's a degree of criticism made of various timings of when applications were made, documents were filed. And I'd just like to contextualise that against the difficulties that we had in relation to the legal aid of my client in the run-up to the fact-finding hearing. That the legal aid that had been in place was suspended while the legal aid agency investigated whether my client continued to meet the means threshold, and it was reinstated a matter of days before the fact-finding hearing commenced before Mr Justice Trowell. And so one sees, for example, that a qualified legal representative had been lined up to put the father's cross-examination in relation to the domestic abuse allegations, so that he wasn't doing so directly, and that person was only discharged a matter of days before the hearing, when those who instruct me and then my junior were instructed for the hearing very much at the last minute. So insofar as there's comment about, for example, the REW application, as it's referred to, coming in late in the day, I'm not sure that the Lordships can take much from it, other than that the father didn't have legal representation until late in the day. On the substance, I respectfully adopt everything that's said in my learned friend for the Guardian's skeleton argument, particularly in relation to the legal framework on this matter, which she's most helpfully set out. And the overarching point in this appeal is that it is an appeal against a fact-finding judgment, and therefore, well, I'm sure your Lordships and your Ladyship are well familiar with the principles. I will, if I may, just run through the headlines. And we have the authorities, the well-known decision of Lord Justice Lewison in the Phage case. The relevant paragraphs are at 114 and 115, which is at authorities 395 to 396. I don't propose to take your Lordships and Ladyship to it, just to flag that that's where they are. And then those principles expanded and restated by Lord Justice Lewison in the Volpe case that my learned friend, the Guardian, refers to in her skeleton argument. That's at paragraphs 2 to 5 of that case, authorities 4 to 7. And finally, just a reference, and again I take this from my learned friend's document, to my Lord Justice Peter Jackson's judgment in S, finding of fact in 2020, and the quotation, simply to remind your Lordship of what you have said before, well established that an appeal court may only interfere with findings of fact in limited circumstances, for example, where there has been a material error of law, serious flaw in the evaluation of the evidence, or where it is shown that the conclusion cannot reasonably be justified. As I say, I'm aware those principles are well known to the court. Taking an overview of this case before we come to the grounds, for the father, our position is that the judgment that Mr Justice Trowell delivered is well above the minimum requirements of what one is looking for in a judgment from a fact-finding hearing. So this is a judge who was immersed over 3 days of evidence and a further day of judgment writing in the nitty-gritty detail of this case. He heard evidence from 3 lay witnesses and from the Guardian, and he did so at length, including giving additional time beyond what was scheduled for those witnesses. The judge was proactive in his management of the case, ensuring that the witnesses understood the questions that were put to them, and when it came to writing his judgment, as he was both entitled and indeed we say required to do, he was proportionate in the issues that he addressed. He declined expressly to deal with every point that had been raised, both because it wasn't appropriate for him to do so, but also because one has to keep in mind the realities of the work of the trial judge. And that links us back to Lord Hoffman's remarks in the well-known passage in the Postkowska case, which is cited amongst other things by Lord Justice Lewison, but the particular officer decision itself is in authority's bundle if we need it. What the judge did was to make findings on what were the key issues, and in doing so, he, as I say, was proportionate and appropriate to what he was being asked to do. He was express in saying at the outset, his paragraph 18, that although necessarily the judgment follows a sequential line, that he was considering the evidence in the round and in its interconnected ways. And as well as saying that he was going to do that, we can see it demonstrated in the actual judgment itself. So to take an example of that, at the judge's paragraph 80, page 44 over to 45 of the core bundle, the judge is seeing there the link between the findings he's making about physical abuse of the children, along with the mother's propensity to lose her temper, as the judge said elsewhere, dramatically at times, including in relation to the children, and the link to the threats that she made in relation to use of a knife. And so we can see, this is just illustrative, that the judge not only gives lip service to the fact that he's seeing the issues in an interconnected way, but that he in fact did that when it came to the core of his judgment. So our position overall is that the judge properly and carefully evaluated the evidence that was before him and made findings that were clearly open to him on the evidence and are not such that this court has a basis for criticising or interfering with those findings. Indeed, insofar as the judge was required to and did do these interconnection of the evidence, somewhat ironically, it seems that it's the appellant's case that seeks to disentangle the issues and look at them in isolation to some extent. So in relation to the failure or refusal to make a finding of alienation, the judge, I'll come back to the detail of this of course, but the judge is entitled not to make the finding of alienation because of his findings in relation to the mother's abusive conduct. When we come to the guidance from the Family Justice Council on which my learned friend places reliance, and perhaps we could have a look at that.
Could I, before you take us to that, because I would like to see that, just ask you this. You and your junior will have a comprehensive understanding of the evidence which we haven't been able to equal, but did the judge hear any evidence to suggest that the relationship between the mother and children was in any way abnormal before July 2023, except insofar as he made findings? In other words, was there any evidence that suggested anything particularly unusual about the relationship before that point in time?
I think the extent of what I can say about that, and I'll refer to my junior, who of course was there and I wasn't at the fact find, but the extent of what I will say about it, subject to what she tells me in a moment, if I may, is that a number of the allegations that are made and the findings that are made, of course, predate the July.
Yes, I understand, but the judge didn't make any other findings than the ones we are considering at the moment. And yeah, the inference that one would naturally draw from the fact that your client was away a lot and left the children with their mother is that the background to this was within the range of ordinary parent-child relationships, both with the father and with the mother.
Well, I think it's fair to say that the extent to which the father was not there was not accepted between the parties, and it's not a matter the judge made any sort of finding about, nor do I think he needed to. I'm not criticising him about that. But there's also part of the father's evidence was that the children were some of the time in the cares of other family members, the aunt in particular. So there were other people involved.
Yes, I'm not interested in the question of whether there were other carers. I'm just assuming that if I went away and spent an hour going through all the papers, the picture that I'd come up with is that until the family broke up, there was no particular issue about the relationship between the children and their mother. Indeed, probably no particular issue in the relationship with their father. It was a family. Is that a fair backcloth to the contested issues which the judge was then coming to deal with?
I think unless I'm told otherwise from Ms Dines, that is right. It's a slightly unusual family dynamic because even on the mother's own case, the parents were cohabiting during this period of time almost as a matter of convenience rather than as a matter of an ongoing intact family, because her case is that having discovered the father's second marriage, that effectively brought an end to the relationship between the parents, but they continued to be in the same house.
Anyhow, well, thank you. And so unless Miss Dines restrains you at a later point, I've understood the answer to my question, and now you're going to go on to the guidance.
Well, yes. So it's in the authorities bundle, and the relevant passage is at authorities 106. So the guidance on this page begins the sort of assessment of how to determine if the three elements that the Family Justice Council say are required to make a finding of alienating behaviour are met. So question 1 at the top of the page, is there evidence the child is reluctant, resistant or refusing to engage? Well, I think we can all accept that is obviously met on the facts of the case, but it's the second question and paragraph 44 towards the bottom of the page that is more significant to this case. Children who show reluctance, resistance or refusal to maintain or build a relationship with a parent who has been abusive towards them or towards the other parent may be found to have a justified response to that parent. The allegation of alienating behaviour will thus fail. And so on the judge's findings of how the mother had behaved, primarily to the children, but also to a lesser extent towards the father, there's justification. Indeed, the judge would have been wrong to have made a finding of alienating behaviour, given his other factual findings. And so when one sees these matters in the interconnected way...
So the allegations relating to the mother's abuse of the children and the allegations against her in respect of alienation are to some extent capable of engaging with each other.
They're intricately interconnected, my lord, because it is the very fact that the children on the judge's findings have a possible reason that is not to do with the father for their attitude towards their mother, is what, as the guidance says, the allegation fails because there is, which is not to say that these issues are rarely straightforward. So it's not to say that there aren't any bases on which the judge might go on to criticise the father. I mean, the judge deals with the father's conduct in relation to contact at some length. But of course, I'm slightly out of turn, but I'll take a point now. The judge also had the evidence from the Kafkas report about Miss Demery's attempts to facilitate contact. And if it's helpful, I can take us to those passages. Just give me a moment to find my reference. It's in the supplementary bundle at page 230. Where the report kicks off, and at 236, the relevant passage.
Could you give the, sorry,
Sorry,
are you dealing with electronic page numbers?
Yes,
or?
I was just going to say, electronic 236, it's hard copy 230. confess, until Ms Guha started making the point earlier, I hadn't noticed the pages were not the same. So all my page numbers are electronic, but I will give the hard copy if that's.
Well, it's very fair that some of us have been adding 6, and now others of us can subtract 6 for the rest of the afternoon.
My lady, I think I'm.
What paragraph are you wanting us to see?
I think I'm actually a page out myself. It's paragraph 28.
Thank you very much. So I have that at paper 231.
231, electronic 237.
And it's a home visit on the 4th of April 2024. Is that the context?
Yes, just above that
Right. Paragraph 28.
heading. Ms Demery is setting out her attempts to set up contact. The children refused to speak to her. They began to sob uncontrollably. Despite my attempts to encourage them, they remained upset. I returned them to the father. And Ms Demery comments on
this. That's dated the 19th of March 2024, as we see at paragraph 14.
Yes. And if one continues down within that same report, electronic 243, hard copy 237, paragraph 64, Ms Demery comments about the children's presentation. She says it's possible the children have been negatively influenced either directly or indirectly by their father. Their tears and distress at the prospect of speaking to their mother seem genuine. And then she contrasts that with their position in relation to their father. So I say this.
Could you just please give the paragraph number that you've just read again?
64.
Thank you very much.
And so insofar as the judge had evidence about, that goes to show only that even a professional as experienced as Ms Demery, and it's hard to imagine a Kafka's guardian with more experience than Ms Demery, even she was not able to facilitate contact. The children told her that the father tried to make them have contact and that they refused, set out in her report. And so looking at the 3 elements of the alienation, alienating behaviours, finding, the middle element is seriously problematic because it's simply not made out, because there are other things going on here other than the father's input. So the interconnection of the various findings, which is still the point I'm making, to be clear, is central to the question of whether it's appropriate. And so the judge, having made the findings he made about the mother's conduct, was then quite right to make or refuse to make a finding of alienating behaviours, because he, having been referred to this guidance by Ms Guha during trial, will have found the missing gap in the middle of it.
Yes, can I just clarify? You're relying on question 2 in the guidance.
Yes.
Not in the minutes. By implication, I think you've referred to question 1. You haven't referred to question 3, but you're not relying on.
I haven't said anything about question 3. So question 1 I would accept is made out. The children are clearly reluctant, refusing, resistant. That's obvious. Question 2 I've just addressed. Question 3, the question being, has one parent engaged in psychological manipulation? In a sense, one doesn't need to get to it because the case falls at 2. But
well, let's just assume it might not.
Yes.
What do you want to say?
So in relation to that, we say there's no evidence to support that. And the judge, in his judgment, says that he has not got the evidence to make a positive finding about that.
But that's the crux of this matter. Where into this analysis 1, 2, 3 does taking children to the far side of the world without telling their other parent fall?
Well, I'm obviously not going to seek to condone that conduct.
Sorry, I mean, I know I put it in a rather rhetorical way, but does it not fall, at least theoretically, in 3?
Well, it depends on the overall circumstances, and I appreciate that's a lawyer's answer to any question, is that it depends on the circumstances. But the father's case is that on arrival in this country, there was then a period of significant time, I think it said 4 months, during which there was contact going on, and the mother concedes it only in relation to the one call where she took a screenshot of the children, but the father's case is that that was part of a wider period of time during which there was contact going on.
So his case, which we don't know what the judge found about it because he didn't make a finding, was that there was ongoing contact for 4 months.
Yes.
Yes. And what was his case about why it stopped?
Forgive me, my lord, if I tell you, I'm afraid I don't know the answer to that. I can take instructions.
Anyhow, I don't want to obstruct you in this particular analysis, but I mean, it seems to me that if there is a situation of alleged alienation, and it's in the context of a child abduction, then the abduction's got to fit in somewhere in the analysis. Does it?
Well, my lord, I think it's one of the pieces of the picture. And I come back to the point that I made, that the children told Miss Demery very clearly that the father was encouraging them to have contact with their mother and that they were refusing to do so. So insofar as there was evidence about what was the father doing behind the scenes, the word from the children's mouths was that he was telling them that they should be speaking to their mother and encouraging them to do so. Now, I'm not suggesting that's the totality of the answer either, but these pieces of the picture come together, and this is all an answer to my lady's question of what do we say about the third limb, in case I'm wrong on the second, and that is that there's a very mixed bag of evidence about the third, and I think I have to accept my Lord Justice Peter Jackson's point that one of those factors, and a significant one, is the abduction, but it's certainly not the only one. And so the judge looking at this in the round was entitled to take into account all of those factors, which included his findings about the mother's conduct.
And going to the judgment, as you're dealing with this alienation point, where does the judge then do that?
Yes, so the discussion begins electronic 45, paragraph 85.
Yes.
And he goes through various points. So the first few paragraphs deal with the father's attitude and the stepmother's attitude, and what he says about that. The father is more pragmatic in seeing that it's in his own interests for contact, not only for him to be seen to be trying, but also to actually facilitate it. This is the end of paragraph 87. And then at 90, the judge kicks off with other than the fact the children were resisting contact, which must be seen in light of her behaviour to them, there is no evidence from which I could draw a positive finding the father was engaged deliberately in trying to turn them against the mother. He says that's...
Well, could we stop there, appreciating that the judge doesn't? How does he fit in the abduction?
I wonder whether I might, although it's
like
hot, whether I can turn the fan off, because I'm slightly struggling to hear what I'm being asked.
Thank you. Yes.
I'm sure we'd all...
we can have it in bursts.
Thank you.
So next time you want a burst, or anybody else wants a burst, let us know. Right, so my question was this, just, and I think you and I would agree that at some point in this discussion of alienation, as you've just told us, the judge has got to factor in all things, including, in a sense, the most striking feature of the case, which was the removal from one country to another. And how do you deal with the argument that would be addressed to the first sentence, which is there was no evidence that the father was engaged deliberately in trying to turn them against their mother? I mean, what's child abduction?
Well, the abduction, we'll come back to this point in more detail if I may, but part of the criticisms that are made of the judge in relation to his finding about the abduction is that he also makes comment about the father's motivations and so on.
Yes, it's part of the same continuum in the appellant's case.
Yes, but our case is that the judge was not only entitled but quite right to consider the context of what happened, because if I can say it this way, there are abductions and abductions, and this is an abduction where there's a whole number of things going on in the motivation, one of which is the father's case in relation to the danger to himself, one of which is the father's concern about the children as girls in Afghanistan not being entitled to any meaningful education after the age of 12, one of which is the general preference for life in the UK compared to Afghanistan, and part of which is this the abduction part, as it would be more conventionally seen in terms of the effect of the relationship between the children and their mother, which I don't seek to downplay, but it's not the only part of this case. This is there are some cases where that is the focus of it, although I would suggest they're relatively rare.
I understand that you understandably say that there ought to be a balance of factors that comes into this, but no evidence from which I could draw a positive finding that the father was engaged deliberately in trying to turn them against the mother.
Yes.
Can that sit beside a finding of abduction? In other words, I mean, it must at the least be utterly reckless if it wasn't deliberate.
Well, if one for a moment accepts the father's case that there was a significant contact in the period after the abduction, up for a period of, say, 4 months, then one has a rather different light on whether the abduction per se can be seen as deliberately trying to turn the children against the mother, which is the point the judge is making here, or whether it is rather more subtle than that. And so what happens later is tricky, because we have the children's own accounts of what they say are their reasons for refusing to have contact. But the short answer that I think I'm giving to my lord's question is that this is compatible with having that in his mind, because there was a period of time on the father's case when the children having been removed from Afghanistan, that wasn't a termination of their relationship.
But your difficulty is you haven't got a finding of fact. The judge doesn't make any finding of fact about that. So you're now trying to explain that reasoning by reference to something that wasn't actually found. And it's disputed, isn't it? It's in dispute whether there was regular contact.
Yeah, I mean, I can...
So your case isn't, in respect, is perhaps not built on the surest foundations at this point.
Well, maybe I'm doing my best in relation to a judgment that I didn't write.
Of course.
But the question for your lordships and your ladyship is not, is this the judgment that you would have written or that I would have written, but was it a reasonable one under the circumstances for the judge to have written? And our case on that is that clearly that it was. If I may, I'm still actually on my sort of opening introductory points, but a couple more of those.
What we've been talking about recently has really been ground 5, hasn't it?
Yes,
I mean, you've large. I mean, either you can come back to it or close it off now, as you prefer. But we do appreciate that they're all to an extent interconnected.
Yes. I suppose it may make sense for me to just finish ground 5, because the only other points really to make about that is that although the judge was relatively dissatisfied with all three of the lay parties in their oral evidence. He specifically says that he finds the father's evidence in this regard believable, and he gives reasons for that, and those reasons come back effectively to the self-interest point that we just looked at, which I think is at the end of 87. Yes, and so although as a general proposition the judge describes the oral evidence from all the parties in words like unhelpful, in this regard he departs from his general view.
Which paragraph did you just cite?
87.
87, thank you very much.
And he's very careful. He says, I need to check myself when believing anything he says, but I'm inclined to believe he's telling the truth in this regard. The stepmother gets rather less credit from the judge in relation to her evidence on this. So one can see the judge is being quite careful and quite nuanced in how he approaches that. So I think those are probably my submissions on ground 5.
Thank you.
But I'll depart back again from the grounds, if I may, back to some overarching comments. One, indeed, is this credibility point, and it comes, if nothing else, to the question of what this court should do if you're inclined to think that the judgment doesn't meet the requirements of Lord Justice Lewis and others' test. And you're invited to make your own findings, and I suggest that you're going to have some difficulty doing that, and it'll be quite a risky.
Could we keep? I found Ms. Guhar's closing passage helpful in relating to understand what the mother wishes to achieve from this appeal. Would you be able at some point, I mean, in your own way, as it were, to take aim at that, so that we have our workings are in order about it?
This is Ms. Guhar's paragraph 74.
Paragraph 74. Yes. I mean, I'm not inviting you to agree that those are, as it were, all the issues or anything of that sort. It's her list of things that she's come for, and this is a good opportunity for you to say why, whatever the outcome of the appeal, those may or may not be open to us.
Well, I'll take the opportunity now to deal with that and to say, given that so much of the case turns on issues of credibility and the presentation of the parties' evidence, and given that criticism is made of the way in which the guardian was or gave her evidence, our case is that it will be extremely difficult and indeed probably inappropriate for this court to substitute findings of fact, because although you have what we're sort of referring to as a transcript, it's not a transcript at all, it's a note of evidence. That note tells you the words, or at least a close approximation of the words, but it doesn't give you anything else.
Can I just say, I didn't detect any criticism of the guardian herself in any submissions that we've heard. I think what we were being asked to consider was whether her position had been, as it were, I mean this kindly, as it were, misused. In other words, that it wasn't what she was there for, that she got drawn into questions and then relied upon. I'm not expressing a view about that, but I don't think that anybody was suggesting that the guardian had exceeded herself or had in any way behaved improperly. It was simply the way that the evidence was drawn out.
Certainly for our part, we make no criticism at all of Miss Demery's, certainly. One of the things that's notable about what Ms. Guhar asks you to do is that she asks you to accept some of the things the judge found and reject other things that the judge found. And that, we say, is an intellectually difficult position to suggest you should adopt. Agree with the judge's findings insofar as they support the mother, and make your own findings the other way insofar as the judge made findings to support the father. Our position is, if you are of the view that this judgment is not valid, the matter will have to be remitted.
Right, you say a Plums and Duff approach is not safe.
No, quite so.
But particularly and again, this is all hypothetical because you're about to tell us why we're not going to be allowing the appeal anyhow. But if we got to this point, it would lead to a judge making a welfare decision, having to interpret findings which obviously he or she hadn't made themselves,
Yeah.
And hadn't even come from a trial court.
Yes. And doesn't need me to make the point, but I'll make it anyway, that it is almost invariably better that the judge who conducts the fact-finding case goes on to conduct the welfare hearing, so that there is continuity of thought process about that. Obviously, that isn't always possible because things happen, but
Well, take the third. I mean, it's just because my eye falls on it. The third part of paragraph 74, which is upholding the findings of wrongful removal.
Yeah.
That's now beyond argument. The wrongful removal of the children because the judge made a finding, it hasn't been appealed.
yes,
Ditto, the assault on the mother on that occasion. Judge made a finding, it hasn't been appealed.
yes,
Nor has it been appealed. B is essentially a point of principle, not a point that depends upon any evidence.
well, we'll obviously come to the detail
I
of
mean,
our
you
submissions
haven't
about that,
yet
but-
come to it, but I'm talking at the moment on a hypothesis that your arguments were not accepted about the judge's treatment of this, and let's suppose Ms. Guha is right about that. I'm not quite sure what more there could be said about the categorization of the facts,
but
if that was right.
I think the difficulty that I have with respect, my lord, is that, as we've been saying throughout the day, the issues in this case are all interconnected. So the question of whether these are findings that are properly made are all interconnected with the other things.
But
the judge-
isn't B a consequence of C? I mean, if C stands, the removal, it wasn't. I mean, there are many abductions which are simple abduction in the sense children taken from country A to country B, and if the first parent left behind wishes to follow, she can follow. What's distinctive about this is a case where there is an abduction followed by a parent who can't follow.
My lord, I respectfully don't accept the premise that these two things follow from each other at all, and I will deal with that in my submissions in detail.
Right, okay. So then, so far as A is concerned, that finding, you say if the appeal was allowed, that would have to be sent back.
Yes, this court is not in a position to find that the mother was not abusive to the children and was not abusive to the father. It's only in a position to find whether or not the judgment below has adequately dealt with the evidence in relation to that. But there's clearly some evidence of that, some of which is undisputed because it's in text messages sent by the mother which she accepts she sent, and voice messages which have been transcribed that she accepts she said. So it can't be the case that this court is in a position to say, as a matter of fact, the mother did not behave in any abusive ways. The best the court can say is Mr Justice Trowell's judgment has flaws in the analysis which require a new judge to look at that in detail.
Right, that's very helpful. Thank you. Was that the end of your, as it were, opening observations?
My lord, only finally to say that in our skeleton argument, which I know the court will have read carefully, we don't need to go to it, but my learned junior who drafted that before my involvement has set out in some detail issues that we take with the way the background of this case is presented. So I just draw the court's attention back to that when...
We just see the paragraphs, we don't have to... it's paragraph 3 of the Steins document,
My lord,
in which she raises a sequence of matters A to H. Is that
yes,
what you're...
that's what I'm referring to, yes, thank you. So I'll deal then with ground 1, having done 5. We'll start back at the beginning. So paragraphs 4 to 17 of our skeleton argument, we set out the detail on the actual evidence of what we say about this, and just pause to reiterate that although my learned friend in her skeleton argument relies on my Lord Justice Peter Jackson's comments in Read B in this court about the steps a judgment needs to go through, the factors a judgment needs to have, we say two things about that. First of all, looking at the list and ticking them off, we say they're all met. But secondly, and more generally, to adopt some remarks of Lord Justice Baker, of course, the list isn't intended to be prescriptive, and I'm sure I will take the risk of saying that I don't imagine my Lord intended it to be, but to be an indicative overview.
So the judgment was soundly structured.
Yes, and that's indeed very much our case. It sets out the background, it sets out the law such as is relevant to this matter, it sets out what the parties' positions were in relation to all the issues, and it sets out the judge's findings. So insofar as it's criticised on that basis, we say there's no justification for that. One of the overarching points in relation to all of the grounds, but it comes out particularly in the list that my learned friend Ms. Guha sets out, the 13 factors she says the judge failed to take into account. One of the difficulties that we say there is about this is that it merges the two parts of the case. It merges what's going on here, which is a fact-finding hearing, with what is still to come, which is the welfare determination. So if one looks at that list, and it's
So it's paragraph 37, is it?
paragraph 37, my lord. Yes, thank you. You're ahead of me. I mean, I'm not going to go through them all, but just as indicative, what was the impact on the children and their mother of the father clandestinely marrying another woman and living a secret double life with her? Well, first of all, we don't accept the premise of how that's put, but that's a welfare question. This is a fact-finding hearing about what happened in relation to the specific allegations, and we don't accept that that was a matter the judge needed to deal with.
I mean, when you say we don't accept the premise of that question, I thought you were bound to accept it at least up until 2020.
It's the I don't accept the clandestine word. The mother didn't know.
Nor did the children.
No, but it wasn't otherwise clandestine. There were 200 people at the wedding, so it wasn't a sort of.
But in a different country.
My lord, yes.
Clandestine in the sense that the people most obviously affected were not.
Well,
I think
I can't get away from that
yes.
point. Obviously, my lady.
I think you're going to reverse out of that position at this point. But anyhow, I do take. I mean, not trying to stop you going through these points, but I do take your point very much that when the allegation of alienation is made, it does tend to blur the issue between fact-finding and welfare, as you say, and an allegation of that sort might very well be best dealt with in a unified hearing, where both fact and welfare can be taken into account. But in relation to other factual matters which are not to do with the alienation issue, this list may have some purchase made, not.
Well, my lord, I don't accept that it does. I don't accept that these are points the judge needed to deal with in a fact-finding judgment, and they are the judge's purpose at this hearing and in his judgment is to set out what are the facts that underpin then the analysis that is going to take place and the welfare determinations that are going to follow. But it doesn't. I mean, there's clearly going to be further evidence, both written and oral, from the parties and from the plenary about what the right thing to happen is. And so the fact that we've established the fact of the abduction doesn't tell us yet what the impact of that on the children has been, doesn't tell us yet what the impact on the mother has been and the relevance of that back to the children's welfare. And it doesn't tell us what the right welfare outcome as a result of that finding are, because we haven't got to that yet. So the judge needed to make findings on the allegations that were being made, and he's done so. So a number of them we say are questions that are still to come, so we can't criticise the judge for not having answered them yet. A number of them really are questions that are sub-questions about credibility. So looking at question 12, why did the father and the stepmother give contradictory and inconsistent evidence? Well, the judge doesn't accept almost any of their evidence about a great many things. Does he need to have had a paragraph where he specifically deals with this question? And we say no, because he's impliedly dealt with it by saying he doesn't accept a great deal of what any of the parties say. So our position about that is these are not matters the judge needed to deal with. And insofar as they were, they needed to be matters that were put squarely in this way to him.
So let's take, I mean, you made a point about there being abductions and abductions earlier on. Let's just follow that up with these examples. Let's suppose there's an abduction from A to B, which is, you might, from experience, put at the lower end of the scale of awfulness, as it were. And then there are abductions that we know that are at the higher end of the scale, which are unspeakable. If there is a split hearing, one is fact-finding, and the other is welfare, your submission would seem to be, and I appreciate that I'm caricaturing it just to blow up what we're thinking about here, that the judge just has to say there's been an abduction from A to B, and does not have to say, but there are these many extenuating factors, and I can quite understand why she ran away because she was being domestically abused and so forth. It's an abduction, but it's that sort of abduction. On the other hand, that this was horrendous, cruel, deliberate abduction, done as it's often done to punish. So take those two. Are you telling us that the judge on fact-finding is not obliged to tell himself, herself, or the next judge that comes along for the second stage where this is on the scale?
I don't think I've said any of those things, and if I did, I didn't mean to. So I certainly don't think the judge is not entitled to make a comment about the context. And in fact, one of my points on this appeal is that the judge was entirely right to make the comments that he made about the context of this.
Right. So he
case.
did characterise what was taking place, and your argument is he was entitled to characterise it in the way that he had.
Well, if I may, I don't think I would use the word characterise. He contextualises it. Whether that's the same thing, maybe it is. Maybe I'm dancing on the head of a pin. But we'll come to the second ground of appeal, which we're coming to in a moment anyway. But the criticism of him is that he is the judge is that he's excused the abduction, and I respectfully don't think that he has at all. He has set out that there was a context, but he's made a clear finding that this is a removal without the mother's consent. What flows from that is yet to be determined. It's a very important part of the welfare determination. But he also was entitled to make comment about what he saw as the father's motivation. But the question that we're looking at, in a sense, is does he then have to go further and also comment about the consequences of the facts that he's found? And that's where I'm trying to draw the line. So not that he can't make findings about what happened and why it happened, or the surrounding context of it happening was. But the question of what the consequences of it were is a question we haven't got to yet. Because, for example, until there's been the fact-finding process, the guardian is not in a position to make an analysis of what the consequences of the facts are for the children. And so the impact on them of it having happened, the impact on them of what happened afterwards in terms of contact and the breakdown of the relationship with the mother, and the question ultimately, which is what the judge is being asked at the next hearing, of what does these children's welfare demand we should do now in consequence. All of those things are still to come.
That submission I can understand. As you say, there's a clear distinction where you have a two-part hearing between the fact-finding stage and then the consequences of the facts found in terms of welfare. That makes sense to me in the moment. But the argument against you is that even in the context of the fact-finding stage, once the central pillar of the father's case, viz. That this was a consensual removal, is demolished, that necessarily has knock-on consequences for the other issues that are in play at fact-finding.
Yes, and most obviously in terms of one of the way the judge is going to assess credibility. But I say he's taken all of that into account, and we can see that, I think, other than in relation to the father's oral evidence on contact, I don't think the judge draws anything very much at all from the father's oral evidence on any other issues. It all comes back to the documentation where he's got...
Is that true? What about the reasons for coming to the UK and bringing children?
Well, he does have the father's oral evidence about that, but he also has a number of documents that that go to the father's case. So it's, well, I suppose what I'm trying to say, maybe I wasn't clear about it, my lady, is that there's nothing else where it is simply the father's oral evidence with nothing else in support of it that leads to the judge to any conclusion. He's not placing reliance solely at any point on the father's oral evidence, and even in relation to the contact issue, he also has what the children told Miss Demery about father encouraging them to have contact. So even there, where he is more positive about the father's oral evidence, it's not the only thing he's got. I'll move to the second ground, which I've already touched on in part. And it's said that the judge has, in effect, excused the father's conduct. Conduct in abducting the children. And so just pausing to say the references in the judgment in relation to, in inverted commas, wrongful removal might be somewhat unhelpful, because those are Hague Convention language, and this court 6 weeks ago or so made the point that one shouldn't incorporate that sort of language into the non-Hague context. But the judge has made the clear finding that there was a removal without the mother's consent, and that...
Sorry, you're going to have to enlighten me as to the significance of the point you've just made, because it comes as complete news to me as a novice. I mean, what's wrong with saying that removal of a child from their mother's care without the mother's consent and taking them to another country is wrongful? Why is that problematic?
The context in which the judgment of this court comes out as a judgment of Lord Justice Cobb, can give the reference if it's helpful, but the context is of a non-Hague Convention abduction like the one we're dealing with in this case, but where the judge is invited to embark on a certain course of analysis, and the upshot of it is to lead the judge to effectively making...
Can I just cut through this with two things, if I may? The first is we'll have a burst of fan, if we may, please. The second is simply this, that wrongful removal is a context from the Hague Convention, and it becomes problematic if it's translated into cases for countries which are not within the Hague Convention, because at that point people may start applying Hague logic, which are specific defences, specific situations, because those are convention arrangements between countries that apply the same standards, whereas non-Hague cases, the same standards are not applied on both sides of the divide. I think it's something to do with that. But I mean, I looked for this. I think the judge mentions abduction once or maybe twice as a concept.
Yes, the relevance of, and the reason I make the point is only this, that in relation to a Hague case, the finding of wrongful removal triggers a consequence, which is that the judge must return the child unless an exception is made out. In the context of this case, where that rule doesn't apply, what the judge is needing to do is to make a finding on the nuanced factual basis, because what he is going to go on to do is to make a welfare determination at final hearing. So, what?
I'm sorry, Mr. George. I apologise, this may be a side issue, but since you've mentioned it, I'm just trying to understand the significance of this. Because if we look at paragraph 22 of the judge's judgment, he sets out, and I believe he's accurate about this, that the first of the mother's allegations is the children were wrongfully removed. Now, there's no reference to Hague Convention, and I assume everybody was operating on the common understanding that this was not a Hague Convention case, and that was not intended to be using those words, as it were, as terms of art. It was simply intending them to be used in their ordinary English meaning. So, what was the judge supposed to do when that was the finding that he was being asked to make? Was he simply supposed to say, well, I couldn't make that finding because that's Hague Convention, I can't go there?
Well, my point, if I may say, is quite a different point, which is that the criticism made by the appellant is that the judge has gone on to look at the surroundings around the actual removal and the lack of consent to the removal. The criticism is, and what you're being asked to do, is to set aside the comments the judge makes around that finding about the father's fears in relation to life in Afghanistan, the father's concerns about the education, and so on. You are not being asked to set aside the finding, obviously that's not in the appellant's case, but you're not being asked by us to set aside the finding of the this being a non-consensual removal, which we can call an abduction and which in lay terms we can call a wrongful removal. But in the context of what is ultimately a welfare case, the criticism that's being made by my learned friend for the mother is that the judge shouldn't have commented on these surrounding issues of the father's
No, I don't think it's that he shouldn't have commented. It's that the comments that he made were an impermissibly inaccurate summary of the overall evidence that largely was either that he'd found or that couldn't be contested. It's not my understanding of the submission that he wasn't entitled to have regard to everything. It was that he basically rode the father out.
Well, I suppose I'm looking at my learned friend's skeleton argument. The judge sought to dilute the import of the finding of abduction by asserting that the father's conduct in wrongfully removing the children was justifiable. If the judge doesn't say justifiable, he doesn't say he's excusing it. He simply says the father removed the children without the mother's consent, and, which is also true, he had these other
Can I just check something from an earlier stage in your submissions? Are you suggesting that if the matter goes back to High Court, that the finding of, let's call it wrongful removal, should be revisited?
Well, my lord, I think our position in general is that if it's going back, it should go back on all these issues, because trying to isolate them.
Well, I mean, the issue of wrongful removal now is the consent issue. Has been done to death has it not?
But
It's been your client has had two chances on that issue. Putting it bluntly, why should he have a third?
Well, my lord, one might say quite a similar thing about a number of the findings against the mother, which Judge Middleton Roy was also unimpressed by the mother in various respects. So it's sauce for the goose in that respect. But I suppose
take consent, which, as my lord has said, is pretty much the hinge in this case.
And the question ties in with the submission you were just making. So just so as you, I make my question a little clearer. If we look at paragraph 50 of the judgment, this is the judge's response to the finding he's asked to make. And he does make the finding. Father did wrongfully remove the children from the care of the mother on 2 occasions. And then he goes on to say, that this is the sentence that my lord drew attention to this morning. He says, in the sense that he removed them without the mother's consent. And thus far, the appellant raises no objection, obviously, because that's a finding in her favour. And the object of the attack is the second half of the paragraph. Because in the second paragraph, although he's made the finding of removal without mother's consent, the judge goes on to say he did so because of fear for his own security, in Afghan, fear for the children, fear for leaving girls behind, and so on. And the attack is those findings are unjustified because it is said that it fails to take into account that what the evidence shows is this was a deliberate, calculated plan to remove the children from their mother in order to set up a new home with the stepmother in this country. And the argument here is that has not been adequately dealt with.
there is also evidence that supports the points the judge alights on here. So he's got the evidence about the father's employment. I mean, I'll just deal briefly. The point is made that 15 years has gone by, so it said, between the employment and the relevant events. But of course, for the vast majority of that period of time, Afghanistan was under the control, effectively, of American armed forces and British armed forces. And so it's
only once the Taliban retake control that
it doesn't
becomes
matter.
a concern.
For the first 11 of those 14 years, the father's got no difficulty during that period of time. So the fact that the length of time is rather deceptive as to what mattered about it. So the judge doesn't have to, in every subsection, deal with all of the points. He's made points in various areas about the father's Home Office documents, the father's oral evidence, the father's approach to various issues. It's scattered throughout the judgment. And my Lord Justice Peter Jackson before lunch was commenting that there's a section which sort of characterises the mother, but no section that does the equivalent to the father. And my response to that is that while I accept there's no paragraph that does a summary of it, actually throughout most of the judgment, the judge is commenting about the father and generally speaking in fairly unfavourable terms.
But paragraph 50 is the only point that jumps into my mind as being some attempt to lift the curtain on the father's mind.
I'm sorry, my lord, would you just say that
It's,
again?
sorry, it's really the only part of the judgment that is some attempt to lift a curtain on the father's mind in all of this. That's the nearest we get, isn't it?
I suppose we see a few other glimpses, for example, in relation to why the father takes the view he does about contact, where the judge comments that it's basically self-interested. So we can see, and this is not particularly complimentary to my client, but insofar as we see the judge's assessment of why he believes that evidence and why.
But can we draw some conclusions from this? It may be that, given the experience of these situations, that there's some common ground to be found. about the interesting question of the overlapping or the butting up of fact-finding and welfare decisions. I would always have thought that the purpose of fact-finding was, as it were, sufficiently to tell the story, on the basis of which the court could then go forward and make an evaluation, to tell the story of what had happened up until now, so that the court could then go and apply the welfare checklist to it, which is a quite different exercise. But there would come a point where fact-finding was so minimal that it wasn't telling the story. Now, are we here engaged in deciding whether the fact-finding was minimal, also, as she suggests, inaccurate, as Ms. Guha suggests, or whether it is effective and focused, as you say it is? Is that really the debate that we're having here? Because there must come a point where a fact-finding exercise becomes unproductive because it simply doesn't tell you the story sufficiently in order to apply the welfare checklist. Now, I don't want to invent this concept without you having a chance to comment on whether that's really what fact-finding is about in these situations.
My version of the answer to what is the purpose of the fact-find is not so much that it's to tell the story, but it's to decide what is in dispute, insofar as what is in dispute is relevant to the welfare of the children.
Well, I'm going to come back to you on that, because I mean, obviously, the first question is what's fact-finding for, is to find facts. But it's not just to find disputed facts, that in most cases, and this is insufficiently recognised, the facts that are undisputed are very often decisive. And facts that are disputed get above themselves. But you need to have a total picture that is sufficient, whether the facts were disputed or undisputed, as a result of the fact-finding, do not. It's not just about disputes.
I don't think I disagree with that, my lord, but of course the primary function that the judge is performing is to resolve the disputed issues. That is what he will be hearing, or she will be hearing evidence about, and the other matters which are not in dispute will get recorded in some sort of part of the background to the judgment. So when one looks back to the list that my lord gave in the case, his name escapes me, B, I think, one of them is recording the relevant background, and insofar as it's not in dispute, it will go into there. But I think what we're talking about in relation to this particular ground and this paragraph that we're looking at is, the question is, to what extent is the judge here entitled to have selected these points to focus on in this paragraph, rather than any other points that he might have chosen? And that brings us right back to Lord Justice Lewison and Igloska, which is that the judge, having looked at the totality of the evidence, must be assumed, unless it is actually shown positively that the contrary is true, to have had in mind what he was supposed to be doing and to have done it. And he doesn't have to say it expressly at every point.
Yeah, but to be sure, and that I take that point. And just to come back to ground two and the points you were making, I mean, I take the point also that the finding to which I was drawing attention in paragraph 50 doesn't come out of the blue. I mean, as you said, it comes as a conclusion that's drawn. For example, and it's just one that my eye falls upon at this moment in time, what he says in paragraph 48, where he says, I accept father's evidence, he felt unsafe, thought it would be much better for children to come to this country. But against that, the argument is, well, why is that a justification for separating the children from their mother? It's one thing for the father to say, well, Afghanistan is an awful place to bring up young girls post-Taliban, and one can well sympathise with that point of view. But if that's the concern, why not bring the whole family to the UK? why does that lead to the conclusion that you take the children away from their mother without her knowledge and consent?
Well, my lord, I would respectfully say that this paragraph doesn't justify what the father does. It says that he...
Why does he use the word because? I do know he did say because.
Well, I suppose the judge is making a factual assessment of what he thinks the father's motivation was, but that's he's commenting on what the father's motivation was. He's not saying the father was right to have that motivation. It's the difference between justifications and reasons. These aren't justifications, they're reasons. The father's reasons are accepted by the judge. The judge doesn't say, so that's all right then. The judge doesn't say, this doesn't harm the children. It doesn't say this hasn't harmed the mother.
So in other words, your response to this ground of appeal is that actually it's based on a mischaracterisation of the judgment. You say this is not the father excusing the wrongful, sorry, the judge excusing the wrongful removal. It's the judge simply recording the father's motivation, you say.
Yes, exactly that, my lord. And the question of what the consequence of the father's actions are going to be, as I said, comes to the next stage, the impact on the children and what the welfare outcome is.
Look at the beginning of paragraph 49. First two sentences. The judge is considering the father's worries. The judge is recording completely without comment the forgery of the mother's consent. What's the purpose of that?
Well, I think those are key findings that the judge has made, particularly the second half of the second of those two sentences is a document created by him to allow him to do what he wants to do. The judge is making a finding, and one that's obviously not at all to my client's credit. And all of that travels forward to the welfare stage of this case.
Well, it might be thought to travel forward to issues concerning the mother's predicament as well, mightn't it? And that's the case that is being made against you, is that, in a sense, the judge appears unmoved by what's taken place in this case.
Well, I suppose I don't accept. He's accepted very little of what the father says in his evidence. He makes findings that various documents have been forged. He makes findings that the father's oral evidence is unreliable, the mother's too, incidentally, and the stepmother's. All of this is being recorded, and the fact that he is recording it without the sort of rhetorical outrage that some judges might choose to include, or some advocates might choose to include in the way they present the case, is a matter of style for the judge.
You say this is a dispassionate set of findings of fact without recourse to colourful adjectives.
My lord, yes, but the actual findings are stark. He hasn't shied away from making very serious findings against both parents, but more so against the father, but against both parents. But yes, he's done so in dispassionate language, and that can't be a basis for appeal. I'm conscious that, having said I'd be about an hour, I'm not done. An hour and a quarter.
I've been hampering you greatly, but I think we can see the road ahead, can't we, in relation to the other grounds, and you'll have time to deal with them.
A good deal of overlap, but I would like to
Yes,
deal
of course.
with the connection that my lord was drawing between the finding of abduction and the finding of abandonment. Because
So are we now on to ground 3?
ground 3, my lord,
Yes.
yes.
So the significance or otherwise of making a finding of abandonment.
Yes. Well, the significance of the finding is twofold. The first is that in itself it's obviously a serious finding of domestic abuse, and I obviously accept that. But there is some importance in looking at the second consequence of it, which is immigration. And if one looks at my learned friend's skeleton, page 313 of the core bundle, paragraph 45 at the top. A principal reason the judge had determined a fact finding was necessary was that a positive finding in favour of the mother's case could facilitate an immigration application by her to travel to this jurisdiction. Well, yes, but that's the consequence. It's not the basis on which the judge should make a finding. In fact, it's quite an improper basis to suggest the judge should make a finding. And my learned friend says the suggestion is that the judge has somehow implied at this hearing on the 22nd of November, that's referred to in the footnote, that somehow this is all on the cards for the mother to get at the hearing, at the fact-finding hearing. And so my learned friend goes on, the judge adopted a contradictory approach in refusing to follow through in making the appropriate finding, and did not provide any reasons for reversing the earlier decision. Right? It may be that I'm misunderstanding what that means, but I'm not aware of what earlier decision there is that can be reversed. The earlier decision was there should be a fact-finding hearing to decide whether this was, amongst other things, whether this was a TNA case or not. The judge has made a number of quite significant findings that go to this overall allegation, and they're particularly...
I think the suggestion is, although I'm not sure that one can actually find this in the judgment, I think the suggestion is that the judge shied away from making a finding of TMA because perhaps he was concerned that it wasn't his function to make such a finding because that was really a matter for the immigration tribunals. But as I say, I don't think you actually find that in the judgment itself.
My lord, insofar as that may be a suggestion that's being made, I would say that's not made out on in the judgment at all.
But well, can you then help me on this? I mean, the judge made it very plain that he was reluctant to use the label. And on one level you can understand that. But on the other hand, the point that's made is that this is a label that is sanctioned in the practice direction, and what's wrong with that?
If facts established that this was transnational spousal abandonment, there's no difficulty at all with using the label, and the label should be used. But if we actually look at what the judge has found, there are some very significant issues in paragraph 52.
Paragraph?
52, my lord, page 39. So the judge reminds himself at the top of the paragraph that he's already made the finding that the children were removed without the mother's consent, and that that was contrary to the father's case. And then from the middle of the paragraph onwards, we get a series of, first of all, criticisms of the father's credibility again, but then, kicking off about 6 lines up, 7 lines up, the mother sees the picture of the children in London.
Yes.
And the response, the judge notes.
None of these, I mean, unless you can take us to, none of the musings in this paragraph have got anything to do with the point. The significance of this is that under Ground 2, the issue was abduction.
Yes.
Ground 3, which is TMA, is an extra feature of the situation because it's abduction without the ability to follow. And so that's the significance of that, because it's a different sort of abduction.
Well,
And so how does anything that the judge says deal with the fact that the inability to follow, which the mother's case was achieved by the father, planned by him, is simply not dealt with.
Well, possibly the first half of 52, which we haven't referred to, refers to the suggestion that the father would help the mother to come, and then the fact that he did not.
Yes, I mean, what I mean is, where is the obstacle to, in a sense, the full TMA picture being completed? Why does anything that's said about the father in the latter part of the paragraph affect that?
Can I take the answer in a number of stages?
Yeah.
Abduction and abandonment may well arise in the same case as they do allegedly on these facts, but oftentimes they don't arise on the same facts at all. So you can abduct, as my lord has already said, the other parent is themselves a British national or have the right to come to this country, and they just simply could follow if that's what they wanted to. Likewise, the classic stranding case often involves the children also being left with the usually mother in the other country. And so there's no abduction part to that in the sense that
you can abduct without abandoning, and you can abandon without abducting.
But it's also the case that you can abduct the children from the mother, and that doesn't amount to a stranding. And in this case, that's our position, is that that's what has happened here. Otherwise, it would be the case that every abduction where the other parent didn't have the legal right to enter and remain effectively in this country
is a stranding.
Would also be a stranding.
Well, this was a stranding.
Well, we don't accept.
What's the possible argument that it wasn't?
The mother has never had any right to enter this country. She's never.
Precisely.
Well, the classic stranding case, quite the contrary, is that it's a person who does have a right to be in this country, and they are left, usually their passport
Well, without
is taken.
their passport, that's just one
What
variant.
is it about the divorce certificate? The fake divorce certificate? I mean, the whole purpose of that was to stop her coming.
Well, the father's basis for being able to be here is as the spouse of a British national. The stepmother's British national, as well as that kind. So his basis, his legal basis, immigration status for being here, is as a spouse. He can't also bring in the mother, whether the divorce is valid or not valid. He can't bring in the mother connected to his immigration status. And this is where the relevance of the judge's findings at the end of paragraph 52 come in, about what the position was ever held out to be. The father did not hold out a promise to bring her here. It was not a plan that either parent thought would be achieved. No deal was done on the basis of it. So she was left behind. Yes, of course. I don't have any difficulty with saying so. But does it amount to abandonment in the sense of the term being used in domestic abuse terms? No.
Well, why, I mean, is it not at the very least highly unsatisfactory that we and you as a newcomer to the case should be trying to work this out? That if the judge didn't think this was transnational marriage abandonment, why did he not explain why it wasn't? I mean, we have his clarification at paragraph 3 of page 48. And all that tells us is the father brought the children here without the mother's consent and without a promise that she would follow. What's not TMA about that?
I have to say, I'm just going back to what Ray A says, which seems to me to be in some difficulty, Mr. George, because it's a pretty broad explanation.
It's when if my lady has the passage, paragraph 70 of Rie, where there's the quotation from the practice direction, and 3.5 lines up from the bottom of the quotation, halfway through the sentence it picks up, in order to prevent her from asserting matrimonial and or residence rights in England and Wales. She's never had matrimonial or residence rights in England and Wales. She had no ability to get matrimonial or residence rights in England and Wales. So this is the case that we will be expanding what the definition of this is, and the consequence will be that a number of people who aren't currently eligible to get the assistance of the Home Office scheme designed for people who came here as spouses from Pakistan or Afghanistan or wherever. The relationship doesn't work out very well, and they are then shipped back by their usually husbands to have the right to return back to their lives in this country that they've had pulled out from under them by the father's conduct in those cases. The people who've never had a right to enter this country.
So the submission is that what took place in this case does not fall within the definition of domestic abuse under paragraph 3 of the PD.
It doesn't fall within transnational spousal abandonment. It may well form some other form of abusive behaviour. I'm not suggesting that this is behaviour that's condoned, but does it fall within this particular bracket?
Right, and the distinction in the paragraph that my lady has been looking at with you is that it cannot be said that this was done in order to prevent her from asserting matrimonial and or residence rights in England and Wales. And that's because she didn't have any rights to assert.
She didn't have any, but
and
also
he had no rights to confer because he thought he was pretending he divorced her.
well, there's one of two things, and either way it leads to the same conclusion. Either there was a divorce, in which case there's no matrimonial relationship, or there was no divorce, but either way he was here on the basis of his relationship with the stepmother, as we're referring to her, and so he can't.
So he has in a sense he's got an escape clause from domestic abuse because of those facts.
My lord, no, I'm not suggesting there isn't a finding to be made, but the finding isn't of transnational spousal
So
abandonment.
we can't call this transnational marriage abandonment because she's no rights to assert and because he'd none to confer.
Yes, it can't. It is
Right.
not.
So we'll have to interpret that in the course of our decision.
Is it a form of controlling behaviour more broadly? Possibly, although the judge hasn't made a finding about
The judge hasn't made any finding adverse to your client at all about that. He hasn't even said he's a domestic abuser.
Well, he hasn't used the term, but he's made a finding of physical abuse.
Well, he said that he hit his wife once.
Yes.
And where else do we find the abuse?
By the father to the mother.
Sorry?
By the father.
Yes. I mean, we find abuse by the mother. I'm aware of that.
Well, he's also made the findings about the abduction, which is obviously a very serious form of abuse of both the children and their other parent. So he doesn't use the words that I just used, but again, that's going forward to the welfare stage. He's made the finding that the father behaved in that way.
Funny enough, I haven't looked at this before, but is it right to say that actually child abduction does not appear in the list of defined forms of domestic abuse?
Certainly as quoted in that paragraph, it doesn't appear. But I don't think there can be any doubt that it's part of it.
Yes, it can be.
It can be. It also cannot be.
Yeah. I mean, a justified escape is an entirely different matter.
Yes, the abduction, which is a flee from serious abuse and so on, is not a form of abuse in itself. Although that doesn't mean it may not be harmful to the child in some ways.
Can I come back, now that you've enlightened us as to the point about matrimonial and or residence rights? Speaking for myself, I'm genuinely grateful for that explanation because I hadn't quite understood the point before. But now I think I understand the question my lady was asking. Because if you go back to Lord Justice Moylan's judgment, having quoted the definition, and you've helpfully explained to us the aspect of that you're relying on, But what Lord Justice Moylan then goes on to say after the quotation is he says, it's clear from the practice direction that the terms of abandonment and stranding are not terms of art, not intended to be applied in a formulaic manner. This is because there are a number of ways in which a spouse might be said to have been abandoned or stranded abroad, and in which the other spouse might have sought to achieve this. So I think the question my lady was asking you was, even if you're right about your point about it not being within the strict definition of where it's preventing her from asserting matrimonial land or residence rights in England and Wales, nevertheless, what's gone on here is within that more general concept to which Lord Justice Moylan was referring.
I suppose I'm back at the point that the effect of the analysis as constructed is every child abduction where the other parent does not have a legal right to enter this country will now be a stranding, almost irrespective of other factors that are going on, because the mere fact of removing the children when they can't follow on this proposed understanding falls within the definition. Even if the person has never had any right to come to this country and the abducting parent has no ability to get them in and can't do anything about it other than not to have come in the first place. But that's the abduction finding.
We also, before parting from this, need to look at the last sentence of 71. So that in a sense, it is a catch-all for things that may not fall directly in one category or another.
And I think I've conceded that there may be other comments to make about the father's conduct, but the appeal before you is that the judge should have made a finding of transnational spousal abandonment. That is the ground of appeal. Shall I move to ground 4?
Thank you very much.
Obviously, as my lord noted earlier, there's some discussion about what the appropriate role of the guardian in this matter was in giving evidence. And I think our overarching position in relation to that is that the judge was actually quite careful about what he was doing in that regard. And so not only does he say in the judgment that it's him who's making the determinations about what is true or not, but if we were taken during the course of my own friend's submissions to parts of the transcript, if we could just look back in the supplementary bundle, sorry, I think it's in the core bundle at 245. This is questions being put to the guardian by Miss Dines for the father. About 6 or so lines down, Miss Dines asks the guardian, "Did you believe them?" She says, "I believe them to a large extent. It's incredibly difficult to know sometimes." And the judge interjects, "This is going to be a question for me to resolve." So the question of whether what was being said was true or not.
I must be on the wrong page. Can you give me the note page again?
Core bundle 245, which I think is the same electronically or hard copy.
I'm in the wrong bundle. That's why I'm in the wrong place. Thank you very much.
While we're on the page, just for reference, about 3 or 4 entries further down, my junior asks a question and the judge interjects again. This is not a welfare hearing. But just to go back to my earlier point, this was, one has to differentiate between the purpose of this hearing and the judge was alive throughout. So,
Can I ask you this question? Why, from your client's perspective, was the guardian giving all of this evidence at all?
well, my lord, a number of the allegations that are made relate to things that the father himself is not witness to. And he can only say what is reported to him by the children, other than where there are contemporaneous messages between the parents, because he's not there. And so the purpose of the evidence from the Guardian is that she has spent significant time with the children and has been asking them.
Yes, and
to
she
report.
puts the results of her investigations into her report.
Yes.
So why does the report not speak for itself?
As a general proposition, it's not uncommon when a professional witness in the role of the Guardian is giving evidence that they'd be asked to expand on certain points, or they've summarised an issue. Can you tell us what child A actually said?
Yeah,
Those
that I
kinds
can
of-
understand, but then one would have expected that to be flagged up in advance.
Well, my lord, of course, I wasn't there, but my
The
understanding
question
is
I
that
have at
that's
the
a-
moment is that the Guardian was called and it seemed to be open season for a roving discussion that nobody was expecting.
well,
Least of all her, I imagine.
Well, I know that some effort was taken by her counsel at the hearing in the closing submissions that we've obviously got in writing to make clear that what the Guardian's evidence went to was really supposed to be limited to what she had been told, and that she wasn't intending to, or shouldn't have been intending to, pass comment on it to any significant extent, although I don't think it's unreasonable for her to comment about her impression of what was said to her. Was it said flatly with no emotion?
Yes.
Was
Well,
it
I
said-
take the example that the children burst into tears or were sobbing, as she puts it. I mean, girls are used to hearing from wishes and feelings officers, Kafka's officers, who say that you know, while doing that, the child appeared to be looking to see what other people were making of it, or something like this, and they are signalling that this had a certain character to it. So they're being eyes and ears. But there's a difference between being eyes and ears, isn't there, and starting to express opinions as to whether this is truthful or not.
Well, of course, the Guardian, to some extent, had done so in her written report. We looked very briefly, start of my submissions, at one of the later paragraphs of her.
Yes, and the Guardian very often will say, if what the children are saying is correct, I would be very concerned about this or that happening in the future. But that's quite different from saying, I'm of the view that what the children are saying represents what actually happened.
The question really is, what weight did the judge put on this? And there's a number of points to the judgment where we can see he is cautious about it. He's cautious about what the children say. He doesn't accept quite a number of the things that they allege, the poisoning allegation that the children make. He doesn't accept that. For example, he notes that the children are very aligned with the father and the stepmother. He notes their very strong wish to remain in this country and not to return to Afghanistan, and the fact that that may well be influencing what they say and why they say it. So
It's quite a big thing, isn't it, that at their age they should come to a country they've never been to before, and never want to go back to the place where everybody that they've known has lived throughout their lives.
it is, and I don't want to make undue remarks, but of course there's an extent to which it depends where one has come from and where one goes to, the extent to which that is an understandable position. So as young women, girls in Afghanistan, their lives will have been extremely different from their lives here. And for them not to want to go back would be more understandable than for children from some other places in the world. The analysis of the findings against the mother runs from paragraphs 66 to 81 of the judgment, and he rejects various allegations. He rejects the suggestion that the cut to the older child's wrist was either deliberate or neglectful in a military sense. Criticisms made by my learned friend of the father for having even made the allegation, but it is notable that what the father actually said in his evidence was quite nuanced. Give me just a moment, I'll just find the page. The 261 of the core bundle is part of the transcript. My learned friend made the point to you that the father alleges that the mother deliberately pushed the older child. And in fact, the word deliberately only comes from Miss Guhar. The father never says deliberately. The questions are at the bottom of that page. And running over to the next page, is it your allegation against M that she pushed the older child onto the sharp toilet roll holder deliberately? Is that your allegation? The father says that's what the child told me, presumably it's supposed to say. Do you say...
Where are you reading from? 261?
The bottom of 261 on anybody's numbering.
Yes, sorry, it's at the very bottom of the page. The allegation that M deliberately pushed M to cause this injury. A says she pushed her. I wasn't at home. Any doubt in your mind?
Yes.
If she says she pushed her, top of 262. That's the
The
nature of the evidence.
Yes, but the father's very clear he wasn't there. So he is reporting what his daughter has told him, and he accepts that he believes what he's been told. If she says she pushed her, she pushed her. That's an acceptance by him internally of the narrative he's been told by the child. But it's very clear he's not in a position to give primary evidence about what actually happened. He's only in a position to give evidence about what he was told, he says, afterwards.
Yeah, so it's a feature of the case that your client gave no evidence from himself of the mother abusing the children.
I think that's right.
Yes, so during the course of a marriage in 2009 or something like this?
Yes, so the children obviously were born later.
14-year marriage, over 10 years of children. He's left with remarks made by the children to him, not first-hand.
Well, yes, remarks made to him, but also made to the Guardian, and made consistently and repeatedly. One of the criticisms that's made is that the allegations of the mother hitting the children weren't put to the mother. And if we turn, please, to 212 of the core bundle. This is the...
Can we break down which of the allegations are we dealing with now?
Well, I'm going to necessarily have to deal with them quite generally. These are the physical,
yes.
hitting on the head, the pulling of the hair.
Right, and 212 is to do with which one?
Well, I have to necessarily take them in a quite general way because the way the questions were put.
Follow you.
I can't get away from the fact that at no point does anybody use the word forehead. At no point does anybody use the word bakery, apart from Ms. Guhar in asking a question of the Guardian, but no, during the cross-examination of the parents, or the mother in particular, it's never put with that level of specificity. So
How can one not? How can you put allegations to an alleged perpetrator in general terms? Surely it's necessary to be specific in the questions. I put it to you that on date X you did Y. You don't say, oh, you've generally been violent or abusive, can you?
well, what we can see on 212, about a third of the way down, SD is my junior. She says, the children report you've hit them on many occasions. Is that true? The mother, the children, no. You've not hit them at all. No, I didn't hit them. I might have slapped them lightly on the legs somehow when they didn't do homework or this type of reasons. I never hit them in a way where they would have been hurt. And then there's a few follow-up questions. But the mother having denied hitting them in any way, well, I think I have to accept would have been much cleaner if there had been a follow-up of the specific allegations on, the head and so on. But the mother having denied having hit them at all, in a sense, that covers the mother's response to these allegations. She's not going to change her view when asked, well, you say you didn't hit them at all, but did you in fact hit her on the forehead?
Well, Miss Tynes did very properly go on the following page. We see that the bathroom incident is referred to halfway down that page and is dealt with in a series of questions.
Yes.
So that was that the judge thought was an accident, and you dealt with the bakery and the injury to the child's forehead. And where is the evidence that the way in which the judge has found it suggests that these children were being assaulted generally?
Well, the specifics of those two, the bakery incident, the hair pulling, which isn't, I don't think, an incident so much as this happened on a number of occasions claim. I think that's how it
was. Hair pulling put to the mother?
I don't think that is put. I'll be corrected if I've missed it, but I don't think that's specifically put. But these specifics come from the Kafkas report, not from the schedule of findings. So the allegations that are put follow.
Right. Well,
I
think the point that we'll have to consider is whether a finding that of that sort of specific nature can be made if it hasn't been put specifically.
And I suppose, my lord, the only thing I'll say finally about that is if the court's of the view that the finding can't be made under those circumstances, this is clearly a matter in my submission that would have to go back. It can't be simply left as a finding that the mother didn't do these things, because
why not if they were never alleged in the first place? And let's take the bakery instance. You accept that that was never in the father's schedule of allegations in the first place.
The father is hampered in the allegations he makes by the fact that in all of these incidents he's not there. It's always a difficulty.
To be sure, but the minute he got the Guardian's report, he could have amended his schedule of allegations. He didn't. So what on earth is the problem? We're simply saying, well, this was never alleged in the first place, and it's compounded by the fact that it wasn't put to the mother in cross-examination either.
Well, my lord, I suppose my only answer to that question is that when we come into the context away from standard civil proceedings and into proceedings about children, what matters, I think I'm quoting from one of my lord's judgments in an appeal from a fact-finding, is getting it right rather than the...
Sorry, the purpose of my question was to test your proposition that a remittal is necessary. And what I'm putting to you is this question. Why does one need a remittal to determine a non-pleaded issue?
Well, the issue is raised by the Kafkas evidence, and
so suddenly the fact that there's a Kafkas report means that everybody's supposed to be having fact-finding about matters that appear in a Kafkas report. So is that the proposition?
My lord, I'm not suggesting that by itself it leads to there being a fact-find, but this is a case where a fact-find has been deemed to be necessary to begin with, and the fact that a fairly serious allegation is raised through a professional does, in my submission, put an obligation on the court to make a determination of whether that is actually true or not.
Speaking for myself, I would accept that the court, which has a somewhat inquisitorial role as well as dealing with issues raised by the individuals, might very well consider that it couldn't go forward confidently without investigating something that had been put in a Guardian's report. But could we just check our facts and look at the Guardian's report in the supplemental bundle, which is at 230 in hard copy, 236. In the electronic, and I'm myself looking at paragraphs 24 and 25, which I won't read out because they they name the children. But these appear to be the accounts that were given, together with 21, which is to do with the wrist. I'm not ruling out that there are other places, and it may be that in a moment Ms. Kelly will help us about this, but this is the sort of information that the judge was acting upon.
As then expanded by Miss Emery in her oral evidence. But yes, this is where
Well,
it's
she's nothing to
starts.
expand. I mean, I think that is the point, that I mean,
Well, I suppose what legitimately she has potentially to expand is you've summarised, you know, I act out the cross-examination. You've summarised what we were told about a bakery incident. Can you please tell us what you were told? What were the child's words? So there's an extent to which she has an ability to expand.
Right.
But
anyhow, that's one place at least, and maybe the place where this data comes from.
yes.
All right.
I think the final thing, if I may, is simply the knife and the blood issue.
We see it there at paragraph 25.
Yes, we see it from the children there. We also see it in the contemporaneous text messages between the parents, which are in the supplementary bundle.
All right, but that's an opposite question to explore. The question I was asking Ms. Guhad this morning. So when one looks at paragraph 25 of the Guardian's report, on one level, the judge's finding is entirely explicable because the child is reported as having said the mother went to visit her sister and returned bleeding with a knife in her hand. So there's no allegation of stabbing, and therefore on that level you can understand why the judge says, I do not find there was a stabbing. But on the other hand, if you take the child's account at face value, there is an unexplained question, which is, where does this blood come from?
Well, one reading of exactly what's said there is the mother is bleeding herself.
Well, indeed.
Well, of course, the child,
That's to me the natural reading of what's said.
and of course that may be a matter that Ms. Emery would have clarified, but it may, of course, also be the case that the child can't differentiate between whether the mother's own blood, because she has a cut on her hand or whatever, or whether she simply literally has blood on her hands. Yeah,
But surely a judge who's making a finding of fact on this question is obliged to distinguish between those two scenarios. Because on one scenario, the mother is a victim, and in the other scenario, she's a perpetrator. And that's elementary when you're trying to distinguish between those two, isn't it?
well, he then has the text messages, which go
Yes, you're about to show us those.
to the
What's the page again?
supplementary bundle, electronic 101, hard copy 96.
Thank you.
There's a previous page, but I think this is the significant one. So on the translation, the father's comments in black and the mother's in blue. And it's said on the mother's behalf that this is somehow taken out of context. But the judge notes in his judgment that no context has ever been provided that would explain what is said. So the mother appears in the messages to concede having a knife and it being.
So are we reading from the bottom up,
I think it goes.
from the top down?
I think the chronology, the timing of it goes top down.
Top down. Well, but you say this, the context is there, but what is the context? Because all we have is a sentence, the knife was not in someone's put in square brackets used, I don't know who's put that in square brackets, but never mind, because of something dishonourable. Well, possibly that's an answer to a question. I don't know, but I mean, speaking for myself, that cries out for some context.
Well, if one goes back up 2 pages, my lord, you get the preceding messages. So this is the father sending a whole series of messages in succession. And so the father's messages say, the entire world knows about you using the knife. In London, Germany, Kabul, even Jalalabad, people know you have hit people with a knife. The children were saying you came home with your hands, when you came home, your hands were covered in blood. This is what leads to those replies over the page.
Right. Well, now you're giving us the context, all right.
My point about the context is, when the mother's cases, these messages are somehow taken out of context, and there's some explanation for them, but she's never offered what that context is supposedly that's missing. They appear to be fairly self-explanatory. The father makes a fairly square allegation that she stabbed someone and come home with a knife and blood, and her response on the second of the pages is to say the knife wasn't used for something dishonourable. So she's sort of defending her actions. The people involved, were a notorious family like yours.
So on page 1, which we have in translation at page 92, this is the mother responding to the photograph of the children which we see going to a party.
Yeah.
Which has been sent by whom?
The photograph,
Yes.
I think by my client. May I just check from him? I don't want to give you the wrong answer. So the children were at an event, and a family friend took the photograph and sent it.
Right, so she's sending it across back again to England, having seen it, and with a series of
Yes.
very angry messages on page 92.
Yeah.
Then your client takes up the picture on the conversation on page 94.
Yes, I'm not sure whether they run.
No, but that's page 94 is the father.
Yes.
It may not be continuous, but it seems to be fairly soon afterwards, because 91, if one looks at the top, it's 7:12, and then 93 is 7:16, so it may not be.
And 96 is them both carrying on the argument. Okay. Right, how are we doing this, Stuart?
My lords, my lady, unless there are other matters that you would.
No, you've
wish me
been
to address.
extremely helpful. Thank you very much indeed. Anything else? Thank you so much.
Sorry, may I just read the note I've been given? Oh, the picture was sent by the mother's cousin to the mother.
Sent, right, so sent from...
From the cousin in England to the mother. She then basically forwards it back with her.
Thank you. And I'll just check, Ms. Dines, nothing to follow with. Thank you very much.
Thank you very much.
Right, now, Miss Kelly, fan or no fan? Or will it depend upon how we get along?
I feel like I'm beyond fan.
All right, let's see how we
I can
go.
muddle on.
It is warm, and I'm sorry about it. So I'm sorry about that. We struggle with this a lot.
Yes. Not a difficulty. My lord, thank you. I will try and be brief generally, and also conscious of the time. It probably does bear repeating that we are dealing with 2 girls who are 14 and just rising 10, who've been the subject of these proceedings for 20 months, and for whom the Guardian would say there's an urgent need for a welfare determination, and for the work that was anticipated at Mr Justice Trowell's order of March of this year, the direct work to prepare them for a reintroduction of contact to their mother, for that to happen. And of course that's all on hold at the moment. And it is a welfare concern that the Guardian has for the children. In terms of the appeal more generally, we have, my lord, as Miss Professor George for the father set out, made reference to the legal framework, creating yourself, my lord, and Volpe, and it's through that lens my lord and my lady, that the Guardian looked at the appeal when it was made and sets out the position. In terms of the Guardian's role in the hearing, the Guardian did not, as will have been seen from the position statement in anticipation of the hearing and the closing submissions that followed the hearing, assert a particular factual position. Both those documents reiterate that. But also, by the 17th of February, and by the time that Mr Justice Trowell made the determination about the re-W hearing, if we look at his paragraph 11 at page 79, when he talks about hearing the children, there must have been, within everyone's contemplation, the Guardian giving some form of evidence. The extent of the use of that evidence may not have been determined, but her giving evidence was clearly, at the very least, within his lordship's contemplation, and it must have been known to the parties that that was a realistic possibility. If I focus just on, in respect of ground 4, my lord, because other matters have been addressed, I don't want to detain you unnecessarily. If we look at...
So the Guardian's main focus is ground 4. Is that what you're?
Well, that's where the Guardian's dragged into the appeal, isn't it?
Yes, but I know, but that might not equate with what the Guardian wants to talk to us about, as it
No,
were. So,
I appreciate
don't
that.
feel that you're limited to that. I just wanted to understand whether you were approaching ground 4 because they were the issues that most concerned the Guardian from the children's point of view, or whether you have other matters
If I can say on the other grounds, my lord, what we have said, we say.
Yeah.
We don't feel it necessary to expand on it. It wasn't the Guardian's role for the purpose of the fact-finding hearing. At the fact-finding hearing, if we look at the judgment, start at page 36 of the judgment, which is PDF 36 as well, and that is where the judge makes reference to the Guardian's evidence being one of the things that he has. He refers to that as 6th in terms of the evidence he has. He goes on, I think, to make 9 in total. It is clear there that the Guardian's evidence is just one component of the many parts of the evidence before him that his lordship considered. At page 38, paragraph 47, we see that there is the, I suppose, the caution to himself about what he must do with the evidence, and that it all must be evaluated and balanced together. Where the Guardian features more specifically, paragraph 66 onwards, which is page 41, what we see there, my lord, is the creation of a framework for the allegations to be considered. And at 67, little 1 to little 7, the judge pulls out the comments and within the Guardian's report that he wishes to consider as the allegations. So that creates a framework for the allegations to be considered. And then what follows is a consideration of all the available evidence as it relates to each allegation. But what does not follow is a reliance on the Guardian as the arbiter of the truth or otherwise of each allegation. There is nothing improper about that use of the Guardian and her evidence that was given. The mother, in her closing submissions, does not raise any issue or any caution as to the Guardian's evidence, the use of the Guardian's evidence, or the weight to be given to the Guardian's evidence, which she seeks to do now. In fact, I think it's little F4, which is page 143.
Oh, maybe we should have a look at that. We haven't seen that document before. So where is that?
sorry,
Are we still
it's in the
core
core bundle.
What are we looking at?
143.
Yes.
That should be the closing submissions on behalf of the mother.
Yes.
And I just use that there, little 4, as an example of reliance on the guardian's evidence, rather than objection to. And as I say, no caution as to the weight or the use.
I'm sorry, I'm being a little slow. Where are you? 143.
Yes, 143
F4.
F4, little 4. Children had a legitimate expectation. There's reference there to the guardian.
Okay.
Not following what the significance of that is. I mean, we've just come from a paragraph on the page which, paragraph 69, the judge says, in answer to a question from me as to what weight I should put on these allegations, has generally told me that some of what they've said has, quote, the ring of truth about it, and that their accounts were, quote, believable to a large extent. What's that doing there?
Well, the guardian was specifically asked that and answered.
Yes, I know, but why is it in the judgment?
Well, I suppose because it's a record of what she said, it doesn't mean that that it has been followed slavishly. And if I use, for example, if we think of the wrist scar, what the children say through Miss Demery is not what the judge finds. There hasn't been a slavish adherence to or a following of the
In
guardian's
paragraph
evidence.
80, he returns to this in order to make a finding of a generalised beating.
He does. He absolutely makes those comments, my lord. But I would say that they are part of the balancing exercise. He feeds them into the pot.
Yeah, sorry, it's not your fault. But can we go back to the submission you were making? Because now I've got the document, I understand the point you're making. So the point you're making is that in the written submissions for the mother at the hearing, it wasn't submitted that judge shouldn't rely upon guardian's assessment of the children's veracity. But Ms. Guer's point when she addressed us on this morning was she didn't think she needed to give the judge that warning because she thought it was self-evident. What's your answer to that?
Well, I think if there's something that you seek to complain about, your submissions are the opportunity to complain about it. And it's not complained about.
Well, it's not a question of whether somebody complains about it. The question to you is whether it's proper.
Whether it's proper.
For a judge to bolster a finding of fact by saying that the guardian
Well, I think what the
thought
judge says, the
it had a
guardian
ring of
says it
truth.
has a ring of truth. That doesn't mean that that's determining his finding. If it were determining his finding, if it was because the guardian says it has a ring of truth, I make that finding, then yes, that would be improper. But my reading of it is that it's not a determining feature. He certainly says it, he records it, but it doesn't follow from that what the guardian has said he makes findings of.
But
Just
isn't one of
because.
the problems that there's no source for the bakery and hair pulling and so on allegation except through the guardian's evidence. There is no other independent evidence of that. Then you put that together with what the judge said about ring of truth.
I see that, my lady, but that's certainly not the guardian's.
I'm not. This is
role.
not a criticism of the guardian.
No, I understand that.
We're looking at the what the judge.
I understand that, and I say again, it's in the balance. It's how much it features in his balancing exercise, and whether or not he's given it undue weight. We say it was a feature of the balancing exercise, and it hasn't been given undue weight. Essentially, I think that's probably it in a nutshell. My lord, I'm conscious that other matters have already been addressed.
Well, don't be unduly influenced by the timing. We want to listen to anything that you think we should. I mean, I do want to ask you at some point about what the differential outcomes might be,
Yes.
depending upon the decision on the appeal, but I want to make sure that you've had the chance to cover every other point.
I have, my lord, thank you, in writing.
Right. So you, as it were, you stand on your skeleton argument. Well, for myself, there wasn't anything in your skeleton argument I particularly wanted to further investigate, except one point which I did find helpful, which was your paragraph 30, because there was a discussion between George and myself about what's a fact-finding hearing, and you put it there in a more legal way. But, is it? I mean, one might consider the word reasonable for factual matrix. I think it may be a good word, because it has to be sufficient and it has to be fair, doesn't it? The factual matrix that you're creating for the welfare decision.
Yes.
And it might fail to be sufficient if it was simply too thin.
Yes.
I mean, as if the findings were simply A, they left Afghanistan on such and such a date, B, they arrived in England on such and such a date, and C, the mother didn't consent. That is my judgment.
Yes.
That would be useless for the welfare judge. Similarly, a factual matrix which was not balanced in its treatment of the evidence, it might be sufficient, but it wasn't, in a sense, using this, true, as it were. It didn't, as I put it, fairly tell the story. Might be not a good matrix to go forward to welfare with.
Yes.
But some variant on your submission, speaking for myself, seems to me to be a, if it wasn't just stating the obvious, it's, of course, a lot depends upon exactly how you express it, but something of that sort.
Something of that sort. And of course, my lord, it's unusual in a fact-finding, or in the outcome of a fact-finding hearing, to have everything clear and determined. We will all know that. It's what is necessary to be determined, so it's the big things. It's almost inevitable after fact-finding hearings that there are things that one or other parties agreed about, or that one or other party feels hasn't been clarified. There isn't a need for everything to be determined, but sufficient.
Yeah, it also tends to be that the fact-finding process tends to deal with what has taken place so far.
Yes.
Does it not? I mean, it will typically particularly focus upon what took place up to the issue of proceedings, because that's a watershed for the dispute coming to court. And it will also very frequently deal with the behaviour of the parties since the proceedings started, in private law in particular. In public law, there's obviously a particular emphasis on when the proceedings started in order to satisfy the threshold. But there's also, isn't there, a sense in which a judge who's finished a judgment about fact-finding can say, well, now we have what's happened so far in a sufficient degree of detail in order to be able to work with that going forward. So by the time you then get to a welfare decision in a split hearing case, there will no doubt be other information that will have come in. And as you say, people may have their pennyworth to throw in about what happened 5 years ago as well.
Yes, it's almost inevitably, my lord.
Right, but
Passage of time normally between a fact-finding and a welfare almost encourages that.
yeah, and but there is a distinction, or it seems to me a helpful thought to be had, that it tends to be, let's gather up what we've got from the past.
Yes.
So we don't have to go back to that again and keep fighting these old battles.
So we just move forward.
We move forward on the basis of what we found about what's happened.
Yes. Yes,
No, thank you for that. The other thing was to do with different possible outcomes. If the appeal is dismissed, as I think you seek, it means that the matter goes back to the judge in October for a 5-day hearing, and That's the only order that we need to make, is to dismiss the appeal.
I think it would actually need to go back to Mr Justice Trowell before that, because the directions that were made in March have been suspended. pending
Were you
appeal.
due to have had a hearing in July or something of that sort?
Yes, for example, I think the Guardian's report was due sometime around about now.
Yes.
So
So time has been lost.
time has been lost, not fatally for the October hearing,
No.
but there needs to be some re-timetabling, whether or not that could be dealt with by consent or we need to go back before his lordship.
Right. So if the appeal is dismissed, then it's a a PTR, if you use the old words, and then the final, trying to save the final hearing in October.
So there was scheduled to be, for example, my lord, this is 195. There was meant to have been a pre-trial review 3 weeks ago, so that didn't happen. The Guardian's analysis had been due the 27th of June. That would need to be re-timetabled.
Okay. Well, we don't need the details of that.
No, so I just
there are
say that's an
issues which are in
example of
that order, which need to be revisited.
They need to be revisited, but there is time. I don't think.
Essentially, the direction of travel hopefully is the same as it was when it left the judge on that hypothesis.
Indeed.
If the appeal was allowed, obviously to an extent it depends upon the basis upon which it's allowed, but does the Guardian wish to say anything about the extent to which findings should be preserved, to the extent to which issues should be returned to the family, to the High Court, the extent to which this court should make any findings of its own? I'm not trying to draw you into
No,
something on which you may not have instructions,
I
but
don't have instructions. Guardian's dealing with an end-of-life case today and wasn't able to be here. But for my part, it's difficult to see how there can be cherry picking of findings that are liked and not liked. There are some, as to terminology perhaps, that may not fall into that category.
so that's ground 3. Yeah, but I mean, would the Guardian be suggesting, and I really don't want to press you one way or the other about this, but we're going to have a third go at consent?
I wouldn't press for that.
You're not impressed with that?
I don't think
You wouldn't
the
press
Guardian
for
would
that?
press for that.
Anything about the other matters that you want to say before?
I don't think so, not usefully, my lord.
No. Thank you very much indeed, Ms Kelly. Ms Guha, any reply?
Yes, my lord, a few points to reply. Firstly, if I could ask the court to look at the case management that we made at page 7 in the supplementary bundle, which I suspect is page 11 or 12. It's the order of the 22nd of November 2024. 11.
Oh, sorry, page.
7 in the paper copy, 11 in the PDF.
Is this the second half of an order? Or the end of an order? What paragraph are you looking at?
Firstly, paragraph 4 in the recitals.
If that father confirms that he maintains
Yes, but I just want to take
the right place.
the point is that at that stage, I raised it on behalf of the mother that the court needed to address the issue as to whether a re-W application was going to be made, and that's why the positions of the parties were confirmed, and then there were further case management directions given. And
Right, so this is on the re-W point, is it?
yes, but it goes further than that, also in respect of schedules. And then asked the court to look at page 10, paragraph 25. There was a clear timetable for the re-W issues. The father was then re-instructing his solicitors, who drafted his Scotch schedule and his statement, and he received legal advice about
I
the
think this is a
re-W
bit
decision.
peripheral, isn't it?
No, but my lord,
I mean, it's a bit, I mean, we get the point that in the end, however, whenever it happened, the father wanted A, to give evidence.
well, it was a point of objection. But the other point is that paragraph 25, the Guardian was directed to file a Scotch schedule if any additional findings were being sought. and
that's
23.
from 23.
23, yes.
But the Guardian didn't seek the findings arising from the
Yes,
report.
from the report, and that is.
Well,
I
I think it would be, I mean, it's a very unusual direction, that, and would be very unusual indeed for CAFCAS in a situation of this sort to launch forth on.
Well, it was actually an invitation of CAFCAS Legal. It was not something that was sought by the other parties.
Right, well, anyhow, they had the chance to do the bakery and the hair pulling and
Yes.
so forth. And if they were going to do that, then they had the obligation to ask your client about it.
Absolutely. So that's the point that arose about whether looking at the three-stage test of alienating behaviours, and looking at the third question of whether there's been psychological manipulation, that is why I invited the court to look at. I just wanted to give the court the reference in the report of the Domestic Abuse Commissioner. It's at page 69 in the authorities bundle, in looking at type 2 allegations and then how the perpetrator can utilise the child as a tool for coercion and control post-separation. And this again emphasises the point of the continuum, and the family court is said to have seen allegations in relation to pathologically manipulative conduct resulting in the intentional undermining of a previously strong relationship between the child and their parent. And that is the issue that we say should have been focal point. The reference to what the children told the Guardian about their past, which has just been referred to, this does tie in with the abuse allegations, because the point being made on behalf of the mother was if the children have a distorted narrative of their past, such as saying their mother did not need them, at paragraph 32 of the Guardian's report, 231, and at paragraph 36 saying that the children themselves said the father had not been violent to their mother, but the mother was violent to the father. It's that distorted narrative that, again, was not evaluated by the judge. The references in respect of the reasons advanced by the father as to why contact stopped are at 265 to 266 of the core bundle. And essentially, the father's case was the children had contact daily, if not 3 times a week, for 4 months, running up to the commencement of these proceedings. And the reason why it stopped is because the children were fearful of a return to Afghanistan. And the reason why the father's case collapses at that point is how does that reconcile with what is reported by the Guardian about the children's presentation? 17th of May 2024, which is a few months later, and the reference is at 278 of the supplementary bundle. The Guardian is reporting that A is dreaming every night that her mother is coming for her and that she is worried that they will catch her.
I'm sorry, which paragraph?
It's paragraph 9. And that she did not want to go to Afghanistan. But this is the premise upon which the father relies upon to say that the children did not want to speak to their mother and refused from January 2024 to do so. And the mother's produced the call log. There were 5 calls between her and the children in January 24 from 8 to 12 minutes duration. And there was no satisfactory explanation why there's the break in the contact. Then, when the Guardian, well, the family court advisor at that stage, was going to observe a period of video call contact for the purposes of assessment. And that is the incongruent aspect of the father's case, that the mother was supposedly speaking to her children. There must have been over 50 calls on his estimation in the latter part of 2024, but it abruptly starts and it never restarts. Turning to the issues about whether it was safe for the father, and it was being said that the relevant period was from 2021 onwards. Well, the father was asked by his own counsel re-examination how he had managed to come in and out of the country safely, and this is at 273 at the court bundle, and it was his opportunity to say, this is where I had been put at risk, but he does not say so. And we know from his visa applications at 287 in the supplementary bundle that in January 2022 he returned to Afghanistan from the UK after spending months living in this country and having been employed there. So his case did not add up in terms of saying that there was a fear for my security. And further, in his visa application at 293, he was asked, is there any other reason you need to stay in the UK? And the answer was no. That was his opportunity to raise assertions about the fear for his safety. But the overarching point, as stated by your lordship, is that how could it be unsafe for the father and the children, but safe for the mother, who the father deliberately decided to leave behind? Your lordships and your lady have already pointed to the pertinent passage at paragraph 71.
Sorry, just to go back to the point you just made. Can you explain to us how, in your client's case, she could have come to the UK? I mean, I appreciate you may say, well, that's not the question, because the question is, why would the father and children leaving Afghanistan? But if we just take as a hypothetical scenario the question of the view is taken that it's unsafe to stay in Afghanistan, and therefore the father and the children come to this country. How, on your client's case, was she in a position to come to the UK?
Her case is she was not in the position to come
Right.
to the UK.
Right. So
There was
that's
no
not
basis.
part of her case.
No.
Her case focuses on their decision to leave.
Yes,
Yeah.
yes.
Okay,
The
understood.
focus is on the intent of the alleged perpetrator.
Understood.
And we don't accept that there is a genuine floodgates argument in this case. In looking at this phenomena, it is intended to condemn parents who deliberately abduct their children with a view to severing relationship between the left behind parent and their children. And one would hope that public judgments such as this is sending out the message that it is an act that will be condemned by the family courts and is seen as a source of extreme significant harm to children. My lord, the last point I just wanted to deal with was the outcome of this case. Of course, the father has an expert team representing him. He should be in a position to say whether he is actively challenging the findings that were made in respect of the abduction. A cross appeal, of course, has not been pursued. And there is a number of permutations in these cases. It's not always black and white in respect of the status of findings that are not appealed. So it is a matter of the father's election as to whether he's going to seek to challenge those findings or not. And of course, in this case, there was overwhelming evidence, and the documentary evidence spoke for itself, and the clear inconsistency in the father's position at the first trial and at the second trial. In respect of the abuse findings, the slightly unusual situation, which again begs the question, why does there need to be rehearing, is that the issue was already astutely made by the court, but the father was not pursuing the findings that the judge ultimately made the main findings of abuse in his schedule of allegations. So the Guardian was not seeking those findings also. So how can it be proportionate or necessary for that issue again to be reopened? And we say that on the abundance of evidence this court has considered, it is entirely open to the court to make a finding in respect of whether there has been alienating behaviours. In respect of the work that could have been done, which to end with this observation, in circumstances where the father was saying he was open to contact, 18 months had passed. That was not dependent on a factual matrix. The court has said that the father was saying the children should speak to their mother, but no work has been able to make any difference. Can I assist the court any further?
No, thank you very much. And thank you to you all for considerable assistance that we've had with this troubling case. The legal representatives will know what will follow, which is that we will take time to consider our decision and let you have it with our reasoned judgments as soon as we possibly can. I can't tell you when that will be, except that it will be as soon as humanly possible. And you'll receive them first in draft for your assistance with any corrections that need to be made to the grammar and basic facts. And for your help, please, in drawing up a draft order that appropriately reflects our conclusions. I have to say this for form's sake, but I'm sure people will observe it strictly, that the draft is given to you as a privilege to enable that process to take place properly. The draft is to be treated as confidential to the lawyers and their clients, and not to be further distributed. Once we have your corrections back, we'll finalise the document and it'll be handed down electronically without the need to trouble any of you to return to court. So thank you again, and my apologies to us all for the temperature in court today. It's not helpful, but you've managed extremely well. Thank you.